Assalamualaikum warahmatullahi wabarakatuh, Prof. I hope you have a good day. First of all, I want to thank you for take your time to watching this video. So this is a video of presentation over my research work that I've been working for over these past few months. More specifically, it's actually over these past few weeks. This is after feedback of a consultation session with you, focusing on the challenges of harmonizing Sharia law and international human rights law in Malaysia. So I am Faris Ahmad Rahman, and you are watching a presentation of a research work. Without further ado, let's move on to the core of this executive summary on the research context. These studies only address the crisis of a multiple legal system in Malaysia. This is only focused on the friction between state level Sharia law and what is conflicting with international human rights law, IHRL, and what are the inquiry we want to evaluate. But what are the objective is to see why the system lack in alignment and to propose, of course, the workable framework for reform on the internal cohesion. For the primary findings, we found that perfect alignment with secular international standard is fundamentally incompatible with Malaysia dual system, especially on the Islamic identity, as Malaysia is a Muslim majority. And because of this, we realize that the core real issue is actually on a internal level, where state lawmaker increasingly enact law that uh, conflicting or contradicting upon federal civil power. Well, this is creating a legislative confusion. So to understand on this matter, we need to know on the dual legal framework. Dual legal framework is basically a system that Malaysia adopt. This is to balancing a secular constitutional power and its international duty, and also in the same way to acknowledge domestic Islamic law development for the state power. Dual system also means that by states and federal have two different separation of power, where it's mentioned in constitutional framework that in ninth schedule, for example, that legislative strictly divided for federal parliament for civil and general criminal law, and for states is focused on Islamic personal or family law. Those are the dual system, the doctrine of separation in Malaysia. On the fragmented jurisdiction, domestic law control Islamic law divided among 14 different states, resulting a legal standard that uh, fluctuate across state borders because each state have their own law. But what are the research problem here actually? So the issue is the main research problem happens when these divided religious power conflict with international legal duties of Malaysia. As for Malaysia, part of United Nations member, and we are of course a member and trying to be a good country by faith to ensure our relation goods with among of other country. Therefore, it is important for us to look at the global commitment. As Malaysia is signatory to CEDAW and CRC, Malaysia bears a serious responsibility under the principle of Pacta Sunt Servanda, where Malaysia has a national obligation to follow the treaties that they are being a signatory party. So the statutory divergence, because of state law, is concerning about moral policing and family management. This frequently violate universal standard of privacy and non-discrimination. Defensive governance, conflict are often framed as fight over religious identity rather than method of equal legal protection for all citizens. So what are the objectives of this research? So basically there is two objectives. First, we want to analyze how do this written law and the real application of state Sharia law can block Malaysia from following its obligation to the human rights standards, specifically on CEDAW, CRC, and CRC. Second would be that what practical legal and constitutional changes can be made to harmonize Sharia law with international human rights law. So this is the first two key objectives that we want to find, but the result can speak different from what are the objective. I will explain on it later on this presentation, but before that, let's look on the research methodology. This utilize a qualitative and comparative legal method where I compared four of Malaysian state, as in Terengganu, Kelantan, Selangor, and Johor. This is because two of the state, Terengganu and Kelantan, are highly conservative and Muslim empowered government, while Selangor and Johor can be seen as more moderate and somewhat centric governance. So we can see is all of the state have this law um, is conflicting with the international human rights law. By focusing on this specific law, we look on those particular issue to see if within this four law have a contradicting uh, principle with what international human rights norms there. Focus on a few of the Islamic law, as in a criminal Sharia law and then a family law, and some on the evidence of the Sharia court law from this state. So let's look on the theoretical framework of this research. International human rights and Sharia law, there is a principle of pacta sunt servanda. What does it mean? This means that countries are strictly the agreement that they have signed, they are signatory party with. However, the issue here is that Malaysia signed with SEDAW and CRC. This is commitment remain unconditional, where Malaysia reserve some of the uh, principle in SEDAW and CRC. Basically, they pick and choose some norms within the human right law to apply in Malaysia Sharia law. Uh, and then the dual quality. From the expert mentioning this very well, where Farid Sufyan Syed described this uh, as accepting universal human right globally while strictly limiting their local use of protect, because they view that universal human right law can be limiting their own sovereignty. This is can be contradict to their own custom. This limiting their tradition and their religious belief. So this is in terms of treaty reservation. Next, on the selective compliance, we looks at Malaysia use broad declaration and reservations against treaty selection that conflicting with international with Sharia law and the federal constitution. And we can see institutional separation. The Sharia court system operate inside closed structure, focusing on traditional readings rather than a model international rules on gender equality. So universal protection are effective placed below the independent power of the state religious authority. What does it mean is Malaysia does not follow a universal international human rights law, the guidance to create law, because they value more the independent power and the state religious authority. Now we look on the constitutional supremacy. Based on the research, we know that the identity of contestation. So the resistance to international human rights law often viewed by local leader as a defense of state power and religious identity rather than a rejection of dignity. Institutional shield. State governments enact Sharia enactment under protection of Article 3 and the ninth schedule, and they viewing this as immune to Western legal control. What does it mean? Is basically a state doing this because they believe the right given to them as a state authority to create the law, bypassing whatever the norms of international human rights that's already been told. Now we can look on the legislative ambiguity. First, these undefined boundaries. The constitutional lines defining the exact power of the states over Islamic law are often opaque. Next is fragmented compliance. State assemblies enact religious law without matching them to federal human rights promises or international treaty duties. Next is asymmetric review. Strict human rights checking is typically reserved for federal and civil law, leaving state religious law largely unchecked. Now, I think we can move on the specific contradiction. What are the legal issues that are contradicting from a local Sharia law, as in Malaysia for Terengganu, Johor, Kelantan, and Selangor, to the few of selected international treaties. Now we move on into the conflicts with CEDAW, the Equality in Marriage and Dissolution. What CEDAW means, CEDAW is actually stands for a Convention on the Elimination of All Form of Discrimination Against Women. So basically, there is a conflicting between local Sharia law and the matter of protecting women human right law. These three legal issues. So first, in the matter of polygamy, where in state position, this is a Sharia law, they permitted the court to use primarily only for male privilege. Basically, only husbands are allowed to have a polygamy. While in CEDAW standard, Article 16.1 says it requires equal rights entering a marriage. Therefore, in international human rights norms, men and women should have an equal right. Therefore, they argue that if women are not allowed to have a multiple husband, therefore human husband also not allowed to have the same privileges. But this is different in state law. And then for the divorce right, the unilateral talak only for husband and conditional fasak for wife. Talak is an Islamic term that allows husband to divorce his wife, while in order for a wife to ask for a divorce, they need to ask for fasak, where they don't specifically have the power, but they need and another eye, in this case is a Sharia law, to show fasak can be proven or not. This is conflicting with Article 16.1c, where it's mentioning about the identical rights in ending marriage. And as for the evidence in the marriage, preference for male witness in Sharia court, while international human rights law standards, Article 15.2 in CEDAW mentioned that identical legal capacity is for both men and women, not it must be weighing more on male or weighing more on a woman. So we look on a specific item. So on the matter of polygamy and inequality, unequal power of structure. Allowing polygamy only for a husband can create an unequal structure within a marriage. The domestic court said that this is focused on a financial ability, which falls under the short of the identical rights standard required by CEDAW. So on the administrative, next on the matter of administrative against substantive, you can see that mechanism like court permission only function as an administrative check rather than a conduit for gender equality in a marital contract. In a matter of divorce and procedural friction, in a unilateral right, we can see that husband retain the right to talak without providing fault. So basically, husband have a power to divorce at his any capacity, representing high level of independent choice. However, a burden of proof can be put in on the wife, where wife must meet specific legal ground to show that the fasak is legitimate. Therefore, it's heavily scrutinized by the court. This creates a systemic imbalance where a wife exits for marriage is dependent on judicial discretion, while the husband exit is largely by his self-determination. Now looks on the challenges of harmonizing this. So basically, it's based on the identity protection. So the reason why these two systems is conflicting is because state authorities argued maintaining traditional family law is a necessary way in order for state to defend their religious identity against foreign secular attacks. In short, they are not looking international human rights law as a way of guidance, because it is completely contradicting with what the religious belief. Structural enclave, family law area are purposely kept safe from equal principle found in secular international agreements, creating institutional resistance to reform. On family matter, purposely not alignment to a secular international agreement, this is of course talking about international human rights law, is because they believe they want to protect what is the legal identity and what is their obligation and responsibility as a Muslim authority. Now let's look on the conflict with the CRC, the best interest of a child. So for context, CRC stands for Convention on the Right of the Child. So we look on the issue. The first is on the marriage age. On a Sharia law, in Malaysia, the legal age for male is 18 and 16 for female. Judicial exception allow younger. While Article CRC standard define that child can be defined as 18 years below. And for the custody, mother loses custody if she remarried a man that is unrelated to the child. While on the CRC standard, it's actually based on best interest of a child as a primary of consideration. On the matter of guardianship, primary natural and legal guardianship is all given priority to the father. While this is contradicting to Article 18.1 or CRC, where it's mentioned that shared equal parental responsibility for both a mother and a father. Let's look on the specific issue. So, on the matter of maturity versus purity, this is on the matter of legal age for marriage. The age divergence. The state enactment accommodate traditional Islamic rule of baligh, as in that person, a woman or a male, must be hit the age of puberty, which allow them to marriage even it's below CRC 18 years old threshold, because in Islamic view, they don't view 18 as a legal age for marriage, because in Islamic tradition, the baligh is in a, there is a few rule of baligh. When it's proven that the girl has hit puberty, it can be married. This is also why the reason women have lower number of age, because women tend to adopt to achieve puberty early compared to male. And of course, for the responsibility of a husband to take care of wife. On the judicial discretion, exception for underage marriage are often influenced by social pressure to legalize premature pregnancies and diverging CRC health mandates. So, on the matter of custody and natural guardianship, the remarried clause automatically disqualified a mother upon remarriage, often ignore the child emotion connection to the psychological welfare. And on the nasab issue, the family line is always favored in legal guardianship wilayah in placing paternal power before shared responsibility. And on the baseline friction, family law enactments create a legal baseline that subordinate individual welfare to formal traditional rules. So we can look on this issue and try to understand what are the challenges in harmonizing this. This is almost similar. The biggest hurdle in states' conscious legal choice is construct a separate between Islamic criminal and family reality. So on a regional correctness, reformer always face a challenge as being seen as questioning religious correctness and underlining that law when suggesting underlining the law as in the Islamic law when suggesting to change to guardianship, because they view that the Islamic law is the truth. And on the textual against secular metric, you can see that Sharia court often follow textual rules instead of secular metric of development, such as child-focused psychological checks. What does it mean? For example, in a court where a child in a custody issue, in Sharia court, it's not based on what the child thinks what is best, rather than its think on what the religion said. So the textual rules here is referring to Al-Quran and of course to the Hadith. Now we can go into the area of conflict with the ICCPR, privacy, autonomy, and freedom of belief. So ICCPR, for context, it stands for International Covenant on Civil and Political Rights. So first on the matter of moral policing. On Sharia law, it is a crime for a khalwat, proximity between unmarried pair, and it can be criminalized. But this is contradict to what ICCPR standard, specifically in Article 17, where it mentioned protection against habitation intrusion into privacy. As their view, the khalwat in this case are matter of privacy. On the penal method issue, judicial whipping of hudud punishment for specific crime has been conducted by the Sharia court as a punishment. This is actually prohibited under ICCPR Article 7, where it prohibits torture, cruel or degrading treatment. And on the belief of apostasy, as in leaving the religion, as in state, it is actually criminalized if you are leaving Islam. It can be considered as rida or dissenting fatwa. But in Article 18 can argue that this is actually taking the freedom of thought, conscious and religious choice of individual. So by having this rule, you literally take away their right of freedom. So what are the challenges of this is actually first on the civilians of intimacy. For the privacy and mirror management, the civilian intimacy here is referring to when a state monitoring a private intimacy is seen as the sovereign duty to protect public morality via principle of hisbah, commanding good and stopping the wrong. So state viewing this as a way to ensure that even the act is conducted in private, state as authorities have a power to prevent in order to commanding goods and stopping wrong. Arbitrary intrusion, however, in ICCPR view, this law represents an intrusion into personal choice, whereas the state view private moral wrong as a threat to social harmony. It can be seen as state is trying to intervene into personal and private life of human. Next, on the matter of penal and methodology and belief, can be seen as a deterrence against degradation, while ICCPR calls the physical punishment as degrading. However, the Sharia law state enactment describes it as a religious duty for deterrence for spiritual belief, as in this is a punishment for them because they do something wrong and it should be punished. And it is not as a degrading, rather than it's more on a deterrence and a spiritual healing. Binding legal identity in Malaysia, being a Muslim is a pillar of civic identity and state power. This is referring for Malaysian Muslim. So making any religious deviation is a crime against state and conscience against safety. ICCPR believe as a private changeable matter, state trade is as a matter of communal and institutional safety. So what are the challenges on this? So basically this is the issue of discriminatory power, where the vague definition of decency and illegal sexuality grant religious enforcement officer wide discrimination power, and this create a conflicting issue with the international human rights standard of legal certainty. To achieve a balance, it will require the state and courts to use Makasi al-Sharia, the higher goal of Islamic law, as an internal mechanism for interpreting text alongside the procedural justice. Now this is internal cohesion and reform section. From external pressure to internal consistency. This part section is basically a solution, a way forward that I propose for this matter. However, before suggesting any plan for legal reform, it is necessary for us to look at the social and knowledge of realities in the legal system in Malaysia. What do I mean by that? Well, the conflict between Sharia law and international human rights law is usually seen as the international failure of a country to follow rules, and in this case, following international human rights law. However, local experts view this matter as differently. For example, as Malaysia is a Malay Muslim majority, and there is a strong position of Islam, and Sharia court are not seen as a tools of oppression. Instead of viewing this as oppression, it was viewed as important pillars for moral order and national identity as part of Malay Muslim majority country. And based on this, the resistance actually comes from the basis different in how things are defined. The way international agreement define a human right is basically heavily focused on secular idealism. This is not really matched with what being promoted in Malaysia, for example, because it does not really match the Islamic idea of right. So the definition of right between secularism and Islam have two distinctive differences. The Islamic idea usually try to balance the freedom of individual with the welfare of the community and religious limit. Therefore, as one of the experts said, even though Malaysia agrees with the universal idea of human dignity, applying it in a real life always require more local and indigenous interpretation onto it. Judging Sharia only through secularism can be viewed as fundamentally wrong. The reason why I said that is because most citizens in Malaysia does not look at the enforcement of Islamic law as something that takes away their freedom. Rather, they will see this as a better system to achieve justice. And in addition, international law is based on the idea that all states are equal and have the right to decide their own future. So talking about Fakta Savanda, Malaysia as a dualist country of that is actually not wrong for Malaysia to not follow and to not apply Fakta Savanda on anything, because Malaysia is dualist country. It is not legally or politically forced to just copy secular treaty into its local law. In short, the main challenge is not about how to force Malaysia to surrender on the outside rule. Instead, it's challenge about how country manage its dual legal system to make sure there is a justice for its citizen. On the judicial overlap, the real problem is not on the lack of international follow through, but internal confusion on the legal jurisdiction. What do I mean by that? The state government have slowly expanded Sharia criminal law into area controlled by federal law, creating crisis of overlapping. What this had anything to do with human rights international law and Sharia law conflicting. So the point we made is, rather than focusing on conflicting, where Malaysia is actually a independent state, however its sovereignty can decide its own future, it is not required for Malaysia to follow international law. Rather than focusing to harmonizing Sharia law to international human rights standard, let's look on the actual matter issue on the Sharia law in Malaysia, which is the inconsistency of the law itself. We can look on the Nick Allen case as an example where Kelantan state created a Sharia criminal offense that just copy federal penal code that already exists. And this is, according to expert, makes many law against the ninth schedule of federal constitution that we mentioned earlier, because it is important to limit state Sharia law only to offenses that are not already covered by federal law. In short, this internal overlap can create an unfairness for the Muslim public, open door to double jeopardy, where a Muslim citizen could technically, by definition, can be punished from both civil and religious court for doing just from a single offense. The main issue here is not about breaking a Western right, actually. What I'm trying to say, rather than focusing on not harmonizing Sharia law to human rights norms, rather is a violation of rule of law and need a legal certainty. That's the main issue. So on the harmonization through cohesion. Basically, instead of trying to make Sharia law to match with CEDAW, to match with CRC, or to match with RCCPR, Malaysia must urgently work to harmonize its Sharia law with the federal constitution and federal civil law. Harmonization should be done by the benefit of its people and not just by pleasing the international treaty organization. The main goal here is to make sure that internal legal unity. In this situation, having equal right does not mean forging secular idea of equality onto Islamic theology. Instead, it means ensuring all Muslims under Sharia law uh, can receive an equal procedural justice. And this means they need a clear limits and protection from confusing law created by the uncoordinated state government. In short, the duty of the state to provide Sharia system that is true to religion, but it's also highly disciplined under the constitution. That is what required in Malaysia. Now is the conclusion and recommendation. So based on our research finding, the true research synthesis is the idea of identity and freedom. This conflict arises from a deep argument about religious identity and national freedom, whereas look on domestic law enforcement is a constitutional duty and not the rejection of human rights. So what we found that international human rights law create a norms that should be followed by majority of its signatory party. However, in the same time, it is also need to consider that states have their own sovereignty and independence, have been given a right from international law to govern and to determine their own future and their own law without external input. Therefore, it is matter of Malaysia right to do Sharia law applying in the states and not following whatever in an international human rights law. But when focusing on the Sharia and human rights matter, the real issue is actually not on the matter of this law is correct or this law is wrong, but this is the matter of lack of unity in Sharia law in Malaysia. So in order to prevent this, we must create a preventive governance. So first, it must go through like state legal advisor, empower penasihat undang-undang negeri as a constitutional gatekeeper in guiding state in creating the enactment for the Sharia. Second, must follow the Makasi al-Sharia method to use higher goal as strict local measure to check law before enactment. Next is on the civil court shield. Trust civil court to use basic structures doctrine as a final shield. This is to avoid similar offense in two different systems, two different law. And last is constitutional unity. Focus on Putrajaya, not Geneva, to find practical local balance. What do I mean by that is Malaysia has to strengthen its own system based on constitutional itself, not based on international human rights law. Next, on a practical local balance. This is a quote taken from the research. Malaysia can balance its dual legal system by representing the religious needs of the majority while following constitutional duty. This provides a strong protection against state law going too far, achieving a local balance instead of forced surrender of outside rule. That will be all of today's presentation. If there is any question, please let me know. I can try my best to answer. Thank you so much and Assalamualaikum.